This is Protected Thoughts from the Intellectual Property Team at McBrayer. This is an overview of state or federal law and regulation and does not constitute legal advice. Services may be performed by others. For more information, visit mcbrayerfirm.com.
Welcome to Protected Thoughts. I am Mary Elise Paul, and I'm here with Bruce Paul. We have a special podcast episode today with our law clerks. Introduce yourselves.
Hi, I am Grace Garner.
I'm Nicole Nocon.
And I'm Jacob Westerman.
We are excited that y'all are here today participating.
Thanks for having us.
Tell us about yourselves.
I am originally from North Carolina. I went to UNC for undergrad and then moved straight from there to Louisville for law school. I have a background in English, and I'm interested in theater, F1, and kind of spend all of my free time kind of in the arts scene.
Nicole, what about you?
Oh, right. I'm originally from Guam, but I spent most of my life here in Louisville. I went to the University of Kentucky for undergrad, and then I got my master's in human resources and employment law. I'm considered a first-gen non-traditional student, so I worked for about 3 years before starting law school. I worked in the public sector for a health department and Metro, and then that was the role I had before I came to law school.
This is Jacob. I went to the University of Louisville for undergrad. I'm from Louisville, Kentucky, born and raised. I actually grew up not far from downtown, but would always come in for U of L sports events, so it definitely biased my decision to attend U of L. I decided to start pursuing law school after doing an internship in undergrad and found I really loved it. I had a degree in political science for my bachelor's degree, and I'm just super excited to be here.
We're glad to have you.
I'm Bruce.
You also enjoy political science, like Jacob?
I do. I was also a political science major and philosophy, and that was 2 decades ago. So I was at a Copyright Society conference recently, and I looked around the room, and I realized, or it occurred to me, that copyright lawyers, and I think to a certain extent trademark lawyers also, are very much people who had an interest in one area of their life early on and didn't quite get to where they wanted to be. And so they became, and I think of it in terms of, and so they became, went to law school and became copyright or trademark lawyer. I think of it very much the same as basically every social studies and PE teacher I've ever had in my life who was like a former baseball player or basketball player who couldn't make the leagues. And so they became teachers.
Artist turned lawyer.
And so I think copyright lawyers tend to be very musical people. They tend to be very, and so that's, welcome to our club to the extent that applies to any of you. And, lobbyists, people who run for office who don't win become lawyers and lobbyists and such. And I think most lawyers wanted to be something else in life and didn't succeed, and so we became lawyers and represent the people that we wanted to be.
I'm looking at Grace here. I think we have this in common. I was a dance major at University of Maryland. I also was an English major, but my heart was with the dance department for many years. And so part of my dance experience at Maryland was we would go lobby Congress every year with Americans for the Arts, and I really enjoyed that experience. And I also wanted to become a dance professor at the time, but that just really wasn't a feasible path forward. I became injured at some point and realized maybe this wasn't what I wanted to do. So pairing that with my English major, I thought law school seemed like a good idea. And also at the time that I was in law school, the Martha Graham Dance Company was going through this copyright dispute of who owned the works, and that was really fascinating to me, of who owned the intellectual property and the dance pieces. And when you are in the choreographic process thinking about, do the dancers own it, really it's the choreographer that tends to own it or the company that tends to own it, but also a lot of times it's a collaborative effort of making art, dances. And so I would think a lot about that. So kind of led me to, in a roundabout way, IP law, and then obviously different things happened where I was focused on trademark and copyright, but I was always interested in intellectual property law. And I look at Grace because she mentioned right off the bat that she was a theater kid.
That is true. My experience is not a major. My kind of peak in musical theater was a few shows in high school and then getting to play the Queen of Hearts in a wheelchair in middle school because I had a full leg cast with a broken ankle. And that's kind of what people remember me for.
Is there a video of this, and why have we not seen it?
There is a DVD at my house in North Carolina. I'm happy to bring it back and we can put it on a little special episode of Protected Thoughts.
It'd be fantastic.
But after that, I was always interested in English and literature and writing, and that still led me to the musical theater space. I still really enjoy musicals, and so when I came to law school, I knew that I wanted to do something that was arts-driven or art-centric, but that still kind of applied my love of writing, and so that's kind of how I landed on IP, and then trademark and copyright both.
Great. What about you all? Any arts background?
Well, I originally, my dream as a kid was to be an engineer and work in space. And yeah, and as the joke is with lawyers, I got to a certain level in math and then realized I couldn't do that. So I decided to pursue my other love, which was kind of, again, political science background, very interested in how laws are made, laws are passed, attended a bunch of, I guess in the performative sense, we would do the youth government programs, and that was one of my favorite parts, was going up and presenting bills and convincing other people to pass them. So that's a major part of also, I think, my desire to go into a practice area of where I could do that in front of a court or, you know, just to other people generally.
For me, when I was 5 up until I think 15, I would tell people I was going to be a comic book artist when I grew up. And I think by the time I got to my senior year of high school, I had to lock in and actually pick a field that I wanted to go into. Still didn't decide until after undergrad that I wanted to pursue law school, but I knew kind of early into undergrad that I wanted to go into human resource and employment law. But art background wise, when I was in undergrad, I used to do commission portraits, like pet portraits. And so my first job out of undergrad, I worked for Chewy.com. Grace and Jacob have heard this multiple times. I mention it, I think, after every sentence that I worked for Chewy, but not making the pet portraits. I was in HR. So that's kind of my artistic experience. I don't know too much about IP law, though.
Do you still draw?
I do. A little bit, but not for money.
You
Just
have
for
to see
fun.
her sketches. She had her notebook open and there's sketches on Post-it notes that are just her quote doodles. They're phenomenal.
That's great.
I do work in the office. It's just quick doodles.
That's awesome.
She's very talented.
Thank you.
I would give appendages to be able to be artistic.
A comic book could still be in her future if she decided that she wanted
If she's
to actually
funny.
make one.
Are you funny?
Unfortunately, no. I wanted to be like...
They're funny in here.
I think Mary Elise probably hears us all the time. We just giggle, but mostly at nothing. So I wanted to be a Batman artist, like a Batman comic artist. Specifically, when I was 5 years old, I was like, I'm going to draw Batman. But here I am.
When I was 5 years old, I wanted to be a dentist, and then I went to the dentist and realized that this probably wasn't for me.
Well, these clerks have taken great initiative and have come up with some IP topics that are of interest to them and that they want to talk about. And some of the topics have come up in their natural daily lives, which I guess is a question. How much does IP intersect with your natural lives? And second part of the question, how much has it changed now that you are working at least somewhat with IP? Do you notice it more popping up?
I'll go first. I'm relatively new. Obviously, I'm just finished my first year in law school, so I don't necessarily know as much as Grace or Nicole may know about this, but I do think that it's certainly changed in terms of both the work I've been able to do so far this summer in helping out in the IP group and also just legally being trained, for the first year of law school. I think I definitely notice it's like kind of that itch in your brain when you see something that may or may not be used in, just going out, seeing it in public, or even like online or something like that on shopping, for example. So I definitely think it's become more prominent, even though it's always kind of been there, if that makes sense.
That's the cool thing about working with McBrayer. I don't think I would have noticed this had I not been in this environment. So Grace being in the same office and you being across the hall, every time I now see something that kind of scratches the itch in my brain. Is that how you say? Is that the phrase? Something that kind of tingles in my brain. I'm like, is that allowed? I'll just turn to Grace and be like, hey, what do you think about this? And she always has an answer. So I think that's really cool. And Grace and I had both run into this on TikTok recently. About 2 months ago, there was an issue that was brought up. So we were scrolling through TikTok, and there's this artist that Grace and I both like. His name is Werner Bronkhorst. He is a South African-born visual artist who now lives in Australia, and he's a contemporary artist. He gained notoriety in 2022. He went viral on TikTok for showing his work, and he became very familiar for this specific art style. So we printed out some exhibits for you all with some pictures of his work. And on that front page, we have the Father's Day Capsule 2025 release from Louis Vuitton of these pocket organizers. And for those of you listening at home, the first one that we have is a pocket organizer that depicts a golf scene. There's another one that has a beach scene, a skiing scene, and a tennis scene. And if you look on the additional pages, those are pictures of Werner Bronkhorst's work. And so whenever we were scrolling on TikTok, we had seen the wallets first, and we immediately knew, even though his name was not affiliated with the post, that it was very similar to Werner's work. And so it kind of flagged in our heads, like, that's a copyright violation, but getting into the weeds legal-wise, I'm not really sure what those implications are. Do you have any initial thoughts?
Well, I think it's also kind of off of Mary Lisa's question, like, even though we now think about IP a lot, everyone else under those videos, like, it was so blatant, that kind of copy of the artistic style, that everyone else, even people that aren't, in the IP space or even lawyers, were pointing out the similarities. And for those of you that don't know it or don't know the wallets or the art style, it's kind of a lot of color blocking and then small little, miniature paintings of like a few people on either a tennis court or on a golf course, and it's almost directly mimicked in the wallets as well.
Has there been any action filed? Do you know?
No. Under a TikTok video, he said, people were like, oh my gosh, are you going to sue Louis Vuitton? And he said, we're handling it. And then at one point, the wallets were taken off the Louis Vuitton website, and then Werner didn't say anything else, and they were put back up a few days after.
When we first started talking about it, we looked on the website and we were searching for these wallets, nowhere to be found. But when we were preparing the outline for this podcast, they were back on the site. We think that maybe money was exchanged, an agreement was made. There was no disparaging comments from Werner online.
Also, in sort of the influencer space recently, there have been lawsuits filed claiming that styles have been infringed. Styles are not copyrightable. Styles are not trademarkable. Registerable, I guess would be the word there. So yeah, there's it's interesting. I can sort of see it, but I don't see exact replicas of the works. I don't even know if his works, like his tennis court work, is a registered copyright in the United States or elsewhere.
Berne Convention could apply, or could it be a derivative? Clean.
Could be. So nothing is ever as clean as it seems. That doesn't mean that Louis Vuitton doesn't make good faith business decisions on these things. When I was in my formative, political years, and Barack Obama was a candidate, everyone learned who Shepard Fairey was, because he famously did this famous work of, there's an Andre the Giant picture that he did in a famous style, I'll just put it that way. I don't have artistic lingo to do this justice. The famous pictures that he did at the beginning, and they had Obey at the top, and I forget if that was a brand or if that was, but Shepard Fairey became the most popular artist ever, or at least at the time, particularly for what was the generation of us who were Barack Obama stans. Fast forward a dozen years, Shepard Fairey was a ripoff artist, or is, a lot of people see him as a person who just deals in other people's works, and but it's art, it's art. you don't think about these things until you find something and you're like, this is cool. I want to be a part of this. And I remember he was selling those prints to support the campaign, but there were lawsuits. He got sued for that image from the artist that did. I guess maybe it was the artist that did Andre the Giant was different than him or something. I forget, but it all is sort of, it gives you, a little brain worm, and you start going and going and wondering, and then throughout time you start to view those old things differently, because as you learn more, you have to reset.
Yeah, you're educated as to what the law is, and
Yeah.
is it infringement, is it not? What are the possible claims that it could be?
And it's also eye of the beholder. I mean, in the infringement world and copyright world, it's fair use is very, very specific. Again,
Transformative
Right.
or not?
again, when growing up, if you grew up in my age and you listened to the Beastie Boys, they were making albums that couldn't be made anymore because they were sampling all sorts of, all rap music was using samples, and, you don't think about that back then. You just think it's cool.
All right, so the collection is back up online. Has Louis Vuitton made any statement about it?
That's the thing. We couldn't find any of the news articles. We couldn't find any of the news articles that were previously online when this first came out. And so, do you all have any insight on what the conversation may have been behind the scenes?
No.
Can't speculate.
Oh, you can't?
No, nothing about that.
Yeah, no, we didn't see any specific statements from Louis Vuitton or from the artist.
But you said that you saw a reel that Werner liked.
What Grace was saying, so someone said, "Are you going to be suing Louis Vuitton?" And he had liked a bunch of comments in that post indicating that he was going to, but he hadn't made any direct statements. So, but they were very clear, like he would reply to comments with check marks, be like, "Hey, are you going to sue?" And then he would have a check mark, and there's records of that. But
now it all seems to be above board, and they're back online. Well, they are.
Or they've made a business decision.
Yeah, it's
again, you can't copyright stuff.
I mean, yeah.
Yeah,
I do like the ski one.
I reckon you do.
I have a question.
Yeah.
Bruce, so obviously a lot of trademark law is focused on consumer perception. Is there any weight given in the copyright space to everyone noticing the similarities between the two?
Is there any weight as to what people think? No, not really. I mean, it could go to a jury, and then you have 6 of your peers or 10 of your peers or whatever jurisdiction you're in, they get to decide. If a judge is deciding it on summary judgment, it's only one set of eyes that matter, or, clerks in the background are also opining on these things. But no, not really. That is one of the factors, but is it the same is sort of a threshold question. Are these two pictures the same? It's kind of a threshold question. But the fact that there aren't like surveys, like in trademark world, there are surveys. How many people would be confused as to the source of this? How many people would be confused as to the affiliation? There's not that in the copyright world.
And Grace, think you've done some work on briefing. So when you're briefing arguments, like on the motions for summary judgments that you've worked on, you are briefing a persuasive argument. Things they aren't different. You're arguing points favorably or unfavorably to convince the judge one way or the other. Speaking of that, you've done a fair amount of IP work in your time here thus far. What area so far seems to be your favorite?
I think I enjoy copyright and trademark both, but I feel like I'm very well suited for trademark, and for some reason it just clicks really easily for me. Whereas, copyright, I get it and I like it, but I think I just like the transactional side of trademark law more, though I do enjoy the litigation for both.
And you have been looking at a number of cases relating to AI, and some generative AI, transactional work. Anything that's interesting to you there?
Yeah, so I am currently writing a note for U of L's Law Review about human authorship and AI and copyright, but of the cases I've been reading, a lot of it is about AI systems, so Midjourney, OpenAI, Meta, that are using copyrighted images or books to train their language learning systems. recently there have been 2 in a California district court, and then there was just a complaint filed by Disney and DreamWorks and Universal. And this is the first time that any big production company has kind of levied this, and all of them are kind of the same, that all these authors and artists take issue with the fact that these larger companies are training their language learning models and then reproducing copyrighted work.
This Disney complaint was filed at the end of June, so approximately 2 weeks ago. So this was just a brand new case that was filed. And remind me, was this was it Star Wars content that's at issue?
It was everything. It was Star Wars, Disney, Marvel, DreamWorks, all of it.
What do you think about this one, Bruce?
We have additional exhibits for your reference if you'd like in the back.
Let's see.
It's just screenshots from Disney. I'm just going to say all the plaintiffs just as Disney from their complaint. And it's just pictures of their copyrighted images on the right and then the outputs from different prompts on Midjourney's AI system on the left.
My opinion on this is it is definitely the one that has captured a lot of people's attention because the visuals of it are, again, as we were talking, people can grow up liking Star Wars, but not thinking about Star Wars as IP and not thinking of ownership of Yoda or Darth Vader. But this complaint does a nice job of showing, not telling. Too many times in lawsuits and complaints, we spend a lot of words. We just spill barrels of ink all over papers. Pieces of paper, writing things, trying to tell people. But the visuals of the complaint and of many IP complaints speak volumes on what's at issue here. And, I think it's interesting because this case is no different than any of the other of these cases, honestly. I mean, Grace referenced one of these some recent cases out of the Northern District of California. One is Kadri versus Meta, and it's a group of 13 authors, one of whom is Sarah Silverman, famous comedian. Quality work. The book that was used to train is great, but it's content of a book, so it's just less persuasive and less interesting for people to get mad at these companies that are training for plugging in these books as one of 1,000 pieces of work, and Meta plucks 50 words or fewer out of that. And it's hard for the plaintiff to make the case that is actually copying.
Well, 2 other things. A picture's worth 1,000 words. So you show, again, like you said, you're showing, you're not telling. And also, it's Disney. Everybody loves Disney. I mean, I'm looking at Jacob's keychain on his desk, which includes a stormtrooper as included in the complaint. Disney's universally loved. So it's content that, like Sarah Silverman's book, is a particular audience, but everybody knows and loves the content. Whether or not you're a Star Wars fan, you know it. I, myself, am not a huge Star Wars fan, but I still know it. And so it seems more, I guess, persuasive, egregious when it's kind of universal content. And not that it's right.
I also think it's an interesting sort of test case because I think, like, for Mickey Mouse, obviously protected, obviously famous. Not that that's a factor in copyright.
Well, every Mickey Mouse, but Steamboat Willie. Steamboat Willie is in the public domain. So.
Well, that's Steamboat Willie.
Just kind of Mickey Mouse.
Steamboat Willie.
Okay.
You can buy Mickey Mouse stuff everywhere. So Disney licenses it everywhere. Walmart, Kroger, Target, Amazon. There is Nike, high brands, low brands. Every brand has a piece of the Mickey Mouse industry. So it's just so prevalent in the market that one wonders what is the value of a Mickey Mouse license.
Well, that's interesting because they still do enforce rights. I mean, they send cease and desist letters to unauthorized uses of the Disney content. So,
Well, and they're suing here.
right, and it's everywhere.
Right, and so it's but Star Wars it seems to me to be sort of more valuable. I saw there's some Simpsons content too.
Spider-Man.
Spider-Man, yeah. And so it's again I think it's the same lawsuit as all the others, but it's more powerful because people feel it when they see it. Like, oh, they've stolen it. They've stolen it. I love these things. They can't do that. Whereas Sarah Silverman's sitting there saying, yeah, they stole my stuff too. Why isn't everyone writing articles about my stuff?
Well, I agree. And that was kind of my point of like, it's easier for people to have the warm and fuzzies over this content. But if this is not allowed with regard to Star Wars, it's equally not allowed with regard to the other content as well.
Yeah. Well, if you read those cases and applying those 4 fair use factors and which kind of, I want to oversimplify this, but it comes down to, can it serve as a market replacement for the original content? And it's going to be hard for Midjourney, the defendant in this Disney Universal case, to say probably won't be a market substitute because those pictures are pretty compelling. But I don't know. We'll see. Hard to be in the prediction business of these things.
Bruce, how do you kind of reconcile that with what is it, Judge Chabria? Is that how you pronounce it?
Chabria.
His argument in the Meta case that the plaintiffs made the wrong argument and that the right argument is talking about market dilution, kind of what you were saying. Do you think that Disney makes a good enough argument in the complaint, without speculating, of course?
Yeah, well, it's not going to be it's not going to be made in the complaint. That's the many millions of dollars that are going to be spent on discovery and surveys and such. So, just thumbnail sketch of this. Market substitute typically asks, is this infringing work going to take the place of the original work in a way that the original work loses all value? In the Meta case, again, dumbing this down, it's a way more complex analysis than this, but the answer was, well, the testimony, the record, which is to say the discovery, revealed that, try as they might, the plaintiffs couldn't use the defendant there. They couldn't recreate long passages of any of the books, of any of the catalog. So where they couldn't show that large passages were being reproduced verbatim in the outputs of these large language models, you can't say there's going to be a market substitute. There's more to it than that, but just from 5,000 feet, that was the analysis. But Judge Chabria said, but hold on, just because there might be evidence in another case, or had we waited a bit and more discovery been conducted, or more analysis, or had the plaintiffs done more with market research or some other statistic, these models can have the ability to recreate fiction or nonfiction or genres that will dilute the particular work's sales. So it may not replace Sarah Silverman's book of comedy and satire in her life and all of that stuff. It may reduce her revenue because it's going to produce something that looks and feels and reads and, is emotionally sort of tethered, stylistically tethered to it in a way that may not replace it, but dilute the market share of that work. And that might be a sufficient evidence to prevail on that factor, which is the most important of the 4 factors. Looking at the pictures, you can see it could be a market substitute. But how those are used, will Midjourney license those pictures to companies and claim the copyrighted works as their own? Probably not, because that is infringement. I mean, that's the analysis, but sort of the sky's the limit in what the evidence might be, could be, will be. We'll see. The complaint, no. There's no predictive value on the complaint, but when they start pouring out the evidence of what works were used, and if I type in Yoda 100 times, how many times does a picture of the actual Yoda output? If I type in lightsaber, how many times does the actual lightsaber output? If it's 100 out of 100, if it's 60 out of 100, it's a market substitute probably. And then are they turning the corner and using that for commercial purposes? Probably.
One of my things is I'm, like I said before, not as well versed, on IP, copyright, trademark, kind of that aspect of the law. But I think with my background, I'm very interested in policy questions, policy decisions, and how the courts view policy in rendering their holdings and rulings. I'm interested, and I don't know if you all have any insights on kind of potentially a court looking to balance the fact that, AI is becoming increasingly prevalent, I think, in every aspect of society, even when it's not necessarily used. You see AI being marketed, or even like ChatGPT things, people using it to do assignments, for example, is a hot topic too. So how do you balance wanting to allow innovation in that field, because I'm sure it's not going to stop anytime soon, but also protecting the rights of the holders who are being infringed?
Well, good question. I, in fact, used ChatGPT last night to try to design our landscaping for the patio. It went okay. So that's kind of striking the balance. So if you have a right and it's being replaced by AI, then it's infringing on the original, or it's replacing the original, then that it's going too far. Essentially, you're undercutting the rights holder, or the idea of innovating to only be replaced by something that AI is putting out. And also, there's lines in copyright law. The Copyright Office is putting out guidance on using generative AI. And so they're telling you how can you use generative AI in innovation and what's protectable. So it's going to continue to be used. But at some point, if there's too much generative AI used in the invention or the content that's created, then you can't claim rights in it, because there's nothing that you are doing that's unique. It's AI that's creating it for you. So there's still, it's obviously all in flux on a case-by-case basis, but there's at least the courts and the Copyright Office are working out some parameters on what's protectable and what's not, so that there still is the encouragement and of innovation.
Well, the statute, it's interesting, because if you want to go way back to the Constitution, the copyright is in the Constitution, and the provision of the Constitution that talks about about the idea of copyright. And then when you read the Copyright Act itself, it is in itself a balancing test. Some things should be protected, and creators of that content should be able to benefit from that, but we shouldn't stymie innovation. We don't do a lot of patents around here, but patents the same way. You have patents that are really important to fund medical devices and medicine, and a lot of money goes into that, because companies know that if we fix that ailment with this medicine, we will get a huge return on investment. But then we don't want to stymie that, and so they become generics in the future. Copyright Act is no different. I think it's designed to protect what is protectable, and there are parameters about what's protectable, styles and ideas not protectable, stuff reduced to writing if unique and new, protectable. But then there's a limit on it, and there are edges. So we've been talking about generative AI. It's the idea of taking these products and in most cases not paying for it, not paying the author of it, but just taking it and training something on it. And the question is, well, is the training for something new? Well, yeah, it is for something new, because we're not training ChatGPT to create carbon copies of these books. We're training them to be able to provide meaningful content that's readable, that's grammatically correct, that is readable in a certain style, that is, that is really, really ingenious. And that's what a transformative use is, which is the first factor of fair use. So the other part of this is, when people talk about generative AI, they're not typically talking about the models and the content that goes into the models. They're talking about the uses. So we talk about deep fakes. We talk about, shaming. We talk about name, image, likeness abuses.
You're talking about the output from the AI.
Outputs that result from this. And there are laws developing and being passed and being considered that protect individuals from those that are new. So that is a new balancing test that legislators across America are considering to try and combat not the creation of the products, but the outputs that honestly harm people.
Do you think that there's a place for legislation when it comes to training them? Because I know that in the Disney complaint, they talk about how Midjourney could put in screening measures for prompts that type in copyrighted characters or have some sort of tracking system for the pool. Do you think there's any, something comparable to like a Data Privacy Act that could be enacted to kind of ward against the training?
I think there could be, but I think that is so far, far, far down the road that I don't see it being foreseeable anytime in the near future. I mean, there's been talk of a federal Data Privacy Act for years and years at this point. There's been talk of a federal right of publicity statute. Bruce's INTA right of publicity committee is drafting federal legislation for that. And while courts are still figuring this out and what this new technology is and means, I think would be decades.
I've not read the complaint. What does it say? It says that it alleges that Midjourney could.
It says, so it's not like in their prayer for relief or anything, but it says that a lot of other generative AI systems have protective measures in place, and they say that Midjourney could minimize or completely eliminate any use of copyrighted characters if they had some sort of tracking system for prompts that input, like draw Mickey Mouse. It'll like say, no, you cannot enter because of copyrighted characters, and then some sort of screening process that they do for images that are outputs of copyrighted characters they then take down.
Well, the screening could be potentially problematic for
these are technological questions, and this is part of the problem with legislation. Is if you look at our elected members of office, do you think they know how to legislate this stuff that they barely use, much less understand? I mean, it is a popular practice for plaintiffs to say in their allegations or in their demands that a defendant could be doing this or should be doing this. And the obvious question in response is, how? Show me. Tell me. Explain it to me. And then they just sort of turn their heads and look the other way because it ain't that easy. These large language models are taught through words. There are images that they are fed. But fundamentally, when you're writing code, you're typing. So let's say that the prompt is Mickey Mouse. Mickey Mouse is trademarked, I assume. But Mickey Mouse is not just having a trademark. I've said Mickey Mouse a bunch of times today. I'm not getting sued for the use of the word Mickey Mouse. So Mickey Mouse could be written into a prompt to say, that's a Mickey Mouse antic. Or Mickey, comma, was mousing around. There are these things, there are fair uses of these things in both trademark and copyright world that prevent absolute ownership. I mean, these are not kings that own these terms, or they do sometimes own the pictures, but again, fair use.
Yeah, and consider, just put it in the context of when you get a cease and desist letter that you've helped draft or respond to in the context of a standard trademark copyright cease and desist letter. No use at all of X, Y, or Z. It's more fine-tuned than that because of what Bruce is saying with regard to fair use, right? There can be permitted uses of certain marks in the context of fair use. Think of when you see television commercials, right? So Neutrogena will be like, compare to X brand. So they're using someone else's trademark branding in their commercial, but it's permitted because it's a comparison, so fair use.
Yeah. I won't name any names because we'll get ourselves in trouble, but I mean, think of any brand and also think, well, that's also a word that's just out there in the universe. And so it's hard. Pictures, a little bit different. So if they're coding with pictures, maybe a little more, filtering maybe a little more, but it's just, if you use Google to do an image search and plug in one of these images, you're going to get hits that this, there, and the other that are identical and in many cases not identical at all. And so these are questions of technology more than law.
I've got one for you, Viking. Range, a Viking.
Mm-hmm. Yeah, an NFL team. Yeah, no, there's no short. Yeah, so it's hard. It's hard. That's the answer. It's hard, which is what makes this more interesting than a lot of other areas of practice of the law. Is very rarely are two cases the same.
I think it's fun because you get to go down the rabbit hole, and also because you do see it pop up in pop culture as you're scrolling, as you're driving. I've gotten messages from you that Grace is laughing. I've gotten messages from her like, I drove by and saw this. I had to go around the block again because I wanted to know if this was permitted or not, which I love because I do the same thing. So it's fun. IP connects us all. Anything else you want to talk about?
I was gonna say, speaking of that, kind of one of the things, I'm a huge sports fan in terms of University of Louisville sports, specifically football and basketball. But one of the things that I never even considered would be IP, and really, I mean, it logically makes sense, but stuff like NIL, which is very prominent in the sports world today, name, image, likeness, and how that connects to IP, what can be protected by, student athletes, for example, not even student athletes, but, professional athletes, which, you can argue there's not really a line anymore. But so on that topic too, that extends to NIL also applying to things like AI voice disputes. And so one of the things that I had a question about was, to what extent, we've talked about visual in terms of, pictures being created by AI. We've talked about, written prompts from AI. What about, this like audio kind of, does that change any part of that analysis? And specifically, because like there's been examples like Scarlett Johansson and Tom Hanks where there's these disputes over, what can someone else make an AI copy? I know there's a website that you can literally put any voice in, it could be real, fake, whatever, and it will generate it in the same style or the same kind of cadence. Where is there a line that's pushed in that, or do you all have any thoughts about that?
Well, voice is your right of publicity, so if someone or AI is using your voice, then it could be an infringement of your right of publicity in your voice. And there have been, I'm sure as you've seen in the news, you mentioned Scarlett Johansson, and there have been others that celebrities have claimed that there have been uses of their voices. So I think there was like a Joe Biden robocall, maybe. It was around election time. Do you remember this?
New Hampshire, during the primary.
During the primary. So all these calls went out that were purporting to be Joe Biden regarding voting. And so there were criminal charges that were brought regarding this call because it was so fraudulent. But yeah, also it's a right of publicity violation to use someone else's voice because your voice is personal to you.
It depends would be my caveat to that, because...
And why? Do you disagree?
I don't disagree. I'm saying it depends because different states have different laws that govern this. So if California is an obvious example. Lots of famous people live and die in California. And Tennessee famously has its statute is called the Elvis Act because Elvis Presley lived and died in Memphis, Tennessee, and every automobile dealership under the sun was using Elvis impersonators to sell their cars and things. And so his estate came and said, this isn't fair. They passed the Elvis Act. California, famous people, name, image, likeness, Tom Hanks or whoever.
Yeah.
And so, Kentucky has a right of publicity statute too. Every state is different. There are starting to be some similarities among them. Some of them are being expanded to include voice, to include. In the old days, it was the radio, the radio commercials that had so and so's voice saying, come on down and buy my car. But now it is online. It's TikToks, it's Instagram images, it's like full videos that show Donald Trump doing crazy things that he didn't actually do, as opposed to anyway. And so the statutes are different in states. In California, for example, if you are deceased, you have to register with the state. It's almost like perfecting a real estate transaction with the state in order to pursue claims, and it can only be brought by like the agent. It's very Californian. You have to be like the agent or the lawyer or an heir. In other states, you can only the right of publicity lasts only so many years after death. So the answer is yes, and not all states have these
Well, we're
statutes.
in Kentucky, so.
We are. But this is heard all over the place.
It's global in reach.
So, yeah. So yeah, it's
Good
real.
question.
Thank you.
Anything else?
Thank you for leading in to say that.
Kind of the same question I had about. Thank you. Kind of the same question I had about the Warner Bronkhorst wallets. Is there anything? I know the Lanham Act doesn't really cover voice, but is there anything consumer perception-wise of people hearing an advertisement and saying, "Oh, that's Scarlett Johansson," any kind of trademark law or unfair competition that could cover things like that for a state that maybe doesn't have a right of publicity statute?
Good question. Under section 1125, you could perhaps have a false endorsement, false affiliation claim that you might pursue under the Lanham Act. Depending on what state you're in, they may have matching state law claims that could also be brought. So a lot of times the states will have state law claims available that could mirror the federal Lanham Act claims that could be brought to. So if you've got a celebrity that appears to be endorsing a product that's really not so, you can often rely on those false endorsement or false affiliation claims as an option, depending on the facts.
False advertising. Yeah. Well, you don't have to have a registered trademark to sue under the Lanham Act, under 1125A of the Lanham Act.
False advertising, you used to have to be a competitor to bring a suit. You guys really brought in a lot of content today. Good job.
Go team.
Thanks for being here.
Thanks for having us.
Well, hopefully you'll join us again sometime. And thank you to all our devoted listeners for tuning in. Remember, we're lawyers, but we're not your lawyers. But we love talking about the law. We'll see you back here next time on Protected Thoughts. Check us out on McBrayerFirm.com.
All content copyright 2024 McBrayer PLLC. All rights reserved.